In every courtroom, there is a silence that speaks louder than words. It is the silence of anticipation, the silence of judgment, the silence that hangs between justice and injustice. Tonight, the Court of the Crane summons a case that has echoed for 61 years. A story first reported in the Korea Times in the 1960s, revisited by outlets such as The Guardian and the New York Times, and finally, overturned in 2025. It is the story of Choi Mal-ja, an 18-year-old girl whose desperate act of survival was branded a crime. A woman who carried the stigma of a conviction for most of her life, and a survivor whose persistence has reshaped South Korea's understanding of self-defense. It was a summer night in 1964 in Gimhae, a small city near Busan. According to court testimony preserved in Busan archives, Choi was walking home when she was ambushed by a 21-year-old man. He pinned her to the ground, blocked her nose to cut off her breath, and forced his tongue into her mouth. Choi's options were stripped away in seconds. As the Korea Times later described it, she was suffocating, trapped, voiceless, powerless. So she did the only thing left. She bit down, so hard that part of his tongue was severed. In that flash of pain, her attacker let go. She escaped. Survival was hers. But as court records would soon show, survival was not the end of her ordeal. It was only the beginning. Under South Korea's Criminal Act, Article 21, a person may use force to defend themselves from an unlawful attack. But the law requires that the force stay within reasonable bounds. If the court decides the defense caused excessive harm compared to the threat, the act can be punished. In 1964, biting off part of an attacker's tongue was judged not as survival, but as going too far. In 1965, the Busan District Court delivered its ruling. Choi was convicted of aggravated bodily injury and sentenced to 10 months in prison, suspended for 2 years. Her attacker, by contrast, was convicted only of trespassing and intimidation. His attempted rape charge was dropped entirely. His punishment? A 6-month suspended sentence. The Independent later called this ruling a mirror of its time, a moment when South Korea's legal system could not bring itself to name sexual assault for what it was. The court's language was unambiguous. Choi had exceeded the reasonable bounds of self-defense. She was not the victim, but the perpetrator. And so the verdict carried a message, not just to Choi, but to every woman who might one day defend herself. Fight back too hard, and the law may come for you. At that time, South Korea's courts often gave leniency to attackers while scrutinizing victims. Sexual assault was rarely prosecuted fully, and judges measured reasonable resistance in ways that favored the accused. In effect, the law punished survival more harshly than attempted rape. For more than 6 decades, the verdict stood. Choi lived with the weight of a criminal record. Even when she applied for jobs or tried to move forward, her past was a stain she could not erase. South Korea in the 1960s and 70s was a country where sexual violence was rarely discussed. Survivors were often silenced, blamed, or pushed aside. Choi raised a family. She aged. But in her own words, shared in a later interview, "I felt like a criminal my whole life for simply trying not to die." Her silence was not peace. It was survival of another kind. In South Korea, criminal records are permanent. Even suspended sentences, where no prison time is served, remain on file. This meant that for 61 years, Choi's official record marked her as violent, not as a survivor. In 2020, the silence cracked. The global Me Too movement had spread to Korea. Women in entertainment, politics, and ordinary life were speaking out. For Choi, a university gender studies course opened an old wound and a possibility. Encouraged by advocates from the Korean Women's Hotline, Choi filed a petition for retrial. At first, the courts refused. The conviction was decades old. The precedent was fixed. But Choi persisted, and in December 2024, the Supreme Court agreed to review her case. And then, in July 2025, something remarkable happened. Prosecutors apologized. They admitted that the original verdict was wrong, that her act was self-defense, and they asked the court to acquit her. On September 10th, 2025, in Busan District Court, Choi Mal-ja was finally acquitted. The court declared her actions to be legitimate self-defense, words she had waited 61 years to hear. As The Guardian reported, she wept in relief. After a lifetime of being branded a criminal, she was now recognized as what she had always been, a survivor. South Korea's Criminal Procedure Act allows retrials if new evidence emerges, or if the original ruling is shown to be unjust. In practice, very few retrials succeed. Choi's case is one of the rare moments when the state itself admitted error and asked for acquittal. To understand how Choi was ever convicted, we must look at South Korea's Criminal Act, Article 21. According to the Seoul Law Group, the law recognizes 3 levels of self-defense. Justifiable self-defense, where an act to repel imminent attack is not punishable. Excessive self-defense, where punishment may be reduced or dismissed. And extraordinary circumstances, such as fear or confusion at night, where even excessive force may go unpunished. On paper, this law protects the vulnerable, but in practice, courts often interpret reasonable bounds narrowly. In 2014, a man in Wonju used an aluminum pole to fight off a burglar. Though he was protecting his home, he was convicted. The injuries he inflicted were deemed too severe. And in many cases of domestic violence, women who defended themselves were punished for what the judges called disproportionate force. Choi's story, while extraordinary in its endurance, is not unique in its injustice. It reflects a long-standing bias in Korean courts, a skepticism of self-defense claims, especially by women. The challenge is this: South Korean judges often measure proportionality with hindsight. In the heat of an attack, a victim does not have the luxury to weigh what is too much. Yet courts historically punish survivors for failing to calibrate their defense as if they were calm observers. Choi's acquittal is more than personal vindication. It is a legal turning point. This ruling signals a broader recognition that sexual assault survivors cannot be expected to measure their resistance neatly, proportionately, while fighting for their lives. Her case now stands as precedent, a beacon for future rulings. It affirms that protecting one's bodily autonomy, even at great cost to an attacker, is legitimate self-defense. For South Korea, the message is clear: survival is not a crime. And for women who have felt silenced, stigmatized, or punished for defending themselves, Choi's case offers something rare: hope. While her acquittal does not rewrite the law itself, it changes its application. Future judges may now look at her case when deciding where reasonable bounds end. It may finally tilt towards protecting survival over punishing it. In Court of the Crane, we weigh stories, not just verdicts. We weigh silence against survival. We weigh the law as it was against the justice it should have been. For 61 years, Choi Mal-ja lived under the shadow of injustice. Now, at last, the scales have shifted. Justice is not always swift. It does not always arrive when it should. But when it does, it carries the weight of every year it was denied. And tonight, the Court of the Crane closes its book on reasonable bounds. May her case remind us that survival should never be branded a crime, and that the measure of justice is not in punishment, but in protection. If you found meaning in tonight's case, remember to like, share, and subscribe. Your voice helps keep the court alive and ensures these stories are never forgotten. And remember, when the law draws its line, ask yourself, are those reasonable bounds meant to protect or to condemn?